Since NYSRPA versus Bruen, the anti-gun community has been clinging to hope that they can ban things like AR-15s, AK-47s, and magazines that hold more than 10 rounds. They've done it because of a single sentence in NYSRPA versus Bruen that they quote ad nauseum as if it's some sort of get-out-of-jail-free card. Guess what? It's not. And I have just published, in my view, the definitive argument that blows up that silly anti-gun argument once and for all. I'll put a link to the article down below. We're going to talk about it here in this video, and I think you're going to be very excited when you see this legal argument, nuclear weapon. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out. It's on Audible. And if you're not following me on @4boxesdiner on Twitter, check it out because I put out more information about the Second Amendment and other legal topics beyond what I can cover in this channel. All right, folks. We're going to get super geeky here, but I think you're going to be extremely happy when we get to the end of this video. And if you're involved in any litigations or any legal argumentations involving gun ban cases, AR-15 ban, quote-unquote assault weapon ban, AK-47 ban, semi-automatic rifle bans, magazine bans, gun roster cases, you're going to really want to pay a careful attention to what I'm going to say. The good news is a lot of what I'm going to say that I'm summarizing in this video is also in a much more extensive, detailed article that I've just published. I'm putting a link to down below. You can check it out for yourself, see if you agree with what I'm about to say, but I think it's pretty compelling stuff. All right, so let's step back. Since NYSRPA versus Bruen, several blue states have engaged in hissy fits, seeking to thumb their noses at the United States Supreme Court because they're angry that the U.S. Supreme Court insists that the text of the Constitution, specifically the text of the right to keep and bear arms in the Second Amendment, should be respected as a fundamental right, just like other rights. Now, it turns out that one of the ways that a lot of these blue states, these anti-gun states, are trying to punish American gun owners and the Supreme Court, so they think, is by trying to ban various types of ordinary, commonly owned firearms, such as AR-15s, AK-47s, and of course that includes necessary components of those weapons, such as magazines that hold more than 10 rounds. We've seen this in places like Washington State and Oregon, Illinois, so on and so on. I don't need to recount all this for you. I think you guys all know that. So let's talk about where we are right now, what the anti-gunners are trying to do, and let me explain to you in extreme detail why what the anti-gunners are trying to do is simply wrong. In 2008, the United States Supreme Court decided Heller. The Heller versus the District of Columbia case held that the Second Amendment's right to keep and bear arms guaranteed that it was a fundamental right to possess firearms. It then went on to look at the text of the Second Amendment and the history associated with the Second Amendment and firearms regulation in America, which is exactly what they did in Bruen, but they did it in Heller as well. And what they concluded was they came up with a test, a legal test. For those legal geeks out there, this is like the rule of decision or the legal test that courts must apply to a particular case. So in Heller, they came up with the in common use test, which is that if a particular type of arm is in common use, which means to possess, by Americans for lawful purposes, it is protected. They can own it for self-defense or any reason, it doesn't matter. It's all lawful purposes. And the reason why we know this is if you look at the Heller case, there's no discussion in any respect of the number of times Americans used handguns in self-defense. There was no discussion of how many times people pulled a trigger of a handgun in self-defense. It was totally irrelevant, because the Supreme Court said in Heller that for whatever the reason is, the court said that Americans prefer and use handguns for self-defense and for lawful purposes. That's what they say. Doesn't matter. Courts, this is what we the people picked, and therefore, because they're in common use by Americans for lawful purposes, they can't be banned. Handguns can't be banned. So the test that the Supreme Court did in Heller was they looked at the text first, and then they looked at the history of the Second Amendment second. And then what they did is they came up with an in common use test, which they derived from the discussion of Miller and some other related historical things, specifically that there was a historical tradition of preventing the carrying of dangerous and unusual weapons. And from that, they said if a weapon is in common use in America, today, in contemporary times, it cannot be banned because by definition, it cannot be dangerous and unusual, because if it's in common use, it cannot possibly be unusual. And since dangerous and unusual is a conjunctive test, meaning that the anti-gunners or the government that's trying to uphold a gun control ban, or a gun ban, I should say, they have to prove that something is both dangerous and unusual. Whatever dangerousness means, it doesn't matter, because if it's in common use, it can't be unusual and therefore cannot be banned. That was the decision of Heller. That was the test that Heller came up with after doing their analysis. And then after that, they then applied the legal test of in common use to the District of Columbia law that banned handguns for all intents and purposes, with very few exceptions, and said that that law that bans handguns in the District of Columbia is unconstitutional and violates the Second Amendment because it violates the in common use test that is the rule of the decision or the test. Okay, that is the law in America in 2008. That is the law today. Now, this is very important to understand this. As I've explained to you repeatedly on this channel, the anti-gunners in America are trying to argue that Heller has somehow been modified by NYSRPA versus Bruen, because Bruen talks a lot about self-defense. But the reason why Bruen talks a lot about self-defense is, again, because the question presented specifically in Bruen was that those individuals that were trying to get to be able to carry handguns in public for self-defense, because they were allowed to carry guns for all other purposes, they just weren't allowed to carry guns for self-defense. Therefore, in Bruen, the Supreme Court talked all about carrying a gun for self-defense, and the Second Amendment right to keep and bear arms includes the right to carry guns for self-defense, because that was the question presented in Bruen. Nothing about Bruen modifies or restricts or limits the holding, the legal test, or anything about Heller. And just as I've explained on this channel, and I've also done in this article down below, what happened was Heller applied the text first and then the historical regulation analysis second, just like it was done in Bruen. The only thing is the Supreme Court had to be more express about how it was done in Bruen, because after the Supreme Court did it in Heller, they realized in the 10 plus years between Heller and 2022 and Bruen, the lower courts, or the inferior courts, as they're referred to under Article 3 of the U.S. Constitution, were screwing it up and getting it completely wrong in like 6 ways to Sunday. So as a consequence, what the Bruen court did in 2022 is they reaffirmed Heller in all respects, and I'll give you the language in just 1 second, and then they go on to say, but almost by a paint-by-numbers approach, here is how you lower courts need to apply the Second Amendment in cases that we, the Supreme Court, have not already decided. Because the Supreme Court in Heller already decided the legal test of in common use, and nothing about Bruen override it or modified it or changed it. So all that Bruen did is explain the methodology that Heller did. It did not change the actual law that Heller set forth, which is if an arm is in common use by Americans for lawful purposes, it's protected, which of course extends to obviously semi-automatic firearms in all respects. They're clearly in common use, as are magazines that hold more than 10 rounds. We know they're in common use because that's why the anti-gunners always complain about them and say things like there's too many guns. I'm not going to bore you with all the evidence that's out there, both survey evidence and industry evidence and testimony and statements made by the ATF and so on and so on. There's really no other argument that these things are in common use. That's again why the anti-gunners want to ban them, because they feel like there are too many. And never forget the 2016 decision in Caetano versus Massachusetts, which again reaffirmed Heller's in common use test, because it discusses how the only types of guns that could possibly be banned are those that are dangerous and unusual, conjunctive test. And of course, Caetano in 2016 dealt with stun guns. So that is the law as we stand here today. The other thing I want to say before I get specifically into the anti-gunner argument is this. When the Supreme Court wants to overrule or get rid of a Supreme Court precedent, it does so expressly, very clearly, unambiguously. Let me give you an example. In 2022, the U.S. Supreme Court case of Dobbs, right? Dobbs overruled Roe v. Wade and said Roe v. Wade was no longer the law of the land. Let me read you this language from the U.S. Supreme Court, the same Supreme Court that decided Bruen. Let's see what they say about Roe v. Wade in Dobbs, and then we can ask ourselves whether or not this similar language can be found vis-a-vis Heller in the Bruen decision, and you'll see the answer is obviously not. So this is what the Supreme Court said in Dobbs. Quote, the Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe v. Wade and Casey arrogated that authority. We now overrule those decisions and return that authority to the people and their elected representatives, period, close quote. So when the Supreme Court wants to overturn and get rid of a Supreme Court precedent, that's what they write, something like that. Now, is there anything in Bruen that sounds like that vis-a-vis the Heller decision? Of course not, absolutely not. Because not only did the Supreme Court in Bruen not overturn or overrule or modify or narrow or limit Heller in any respect, it reaffirmed it. Why do I say that? Let's take a look here at just two clauses. In addition, by my count, which I talk about in my article, there's dozens and dozens, I think upwards of 80 references to Heller in Bruen, all of which are favorable to the decision in Heller. They're reaffirming Heller. They're not narrowing it, because the anti-gunner argument, and you'll see why in a second, is all about narrowing Heller and getting rid of it, but they can't. There's nothing in Bruen that does that. Here are just two sentences in Bruen itself that demonstrates beyond a doubt that Heller's law, which we love because, again, it prevents them from banning commonly owned firearms, such as AR-15s and magazines that hold more than 10 rounds. At a minimum, it does that, which is very good for us. Here's what the Bruen court said. This is what the Supreme Court said in Bruen. And on one page, it says this, quote, "In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulation. Only if the firearm regulation is consistent with this nation's historical tradition may a court conclude the individual's conduct falls outside the Second Amendment's unqualified command," period, close quote. That lays out a methodology of how to decide Second Amendment cases. But it doesn't overrule Heller. It specifically looks to Heller to teach people how to do it. Again, the start of what I just read begins with this, quote, "In keeping with Heller." You see, Heller remains good law, which means in all these arms ban cases, the only question is, are these blue states trying to ban arms, or the sale of arms, the possession of arms, the acquisition of these arms that are in common use by Americans for lawful purposes? They undeniably are doing so. And they are undeniably not allowed to do that under the Heller precedent. Now let me carry on. There's another instance, there's approximately 80 instances, but here's a second major one, where again, the Bruen court, and you'll see why this is so important, the Bruen court is reaffirming Heller and following Heller. Heller is good law, it has to be applied. Here's what the Supreme Court said in Bruen about Heller. Again, ready? Quote, "In Heller, we began with a textual analysis focused on the normal and ordinary meaning of the Second Amendment's language. From there, we assessed whether our initial conclusion was confirmed by the historical background of the Second Amendment," and then it goes on. But here what I just said is extremely important for you litigators out there watching this. This is what the Supreme Court said, quote, "In Heller, we begin with a textual analysis focused on the normal and the ordinary meaning of the Second Amendment's language." Again, start with text. From there, after text, we assessed whether our initial conclusion was confirmed by the historical background of the Second Amendment, and then they go on. The point is that the Bruen test of look to the text of the Second Amendment first, and then look to see what the historical tradition of firearms regulation, which means actual laws actually enforced in America is, to try to figure out what the scope of the Second Amendment includes and what it might not include. That text first, history second, is what Heller did. Bruen is the same thing as Heller. They're identical. The only difference is that the Bruen decision basically does a paint-by-number analysis of the methodology that Heller did in the gun ban case and said, going forward, lower court, inferior courts, when you are confronting a Second Amendment challenge to a gun control law that Heller did not already decide, or that Bruen did not already decide, This is the methodology, the paint-by-number methodology that you're supposed to follow. It is not an excuse or opportunity for you, lower court, to make stuff up involving cases and issues that the Supreme Court has already decided, because they're called the Supreme Court under Article 3 for a reason, and you're called an inferior court for a reason as well. It is your job to look to the Supreme Court and not try to get around it. If you try to get around the Supreme Court precedent, you are not doing your job. Now, I know that I've laid out a very strong foundation here for you, but it's important that you understand this foundation before we get to the specific argument that is the only argument, in my view. I repeat, this is literally like the only argument that the anti-gun movement in America is making in support of their gun bans. Everything else they say is nonsensical, including this, but this is the hook. This sentence from NYSRPA versus Bruen is the only hook the anti-gunners have to justify their gun ban, and it's all hooey and wrong. In Bruen, the following sentence appears. And it is this sentence that the anti-gunners are grabbing onto for hope. It actually doesn't give them hope, if you're honest, as I see it. Here is what the language is from Bruen that the anti-gunners use to justify their bans. Quote, while the historical analogies here and in Heller, reaffirming Heller yet again, while the historical analogies here and in Heller are relatively simple to draw, other cases, ding, 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 listen, other cases besides Bruen and other cases besides Heller, other cases implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. Period, close quote. You see what I just said? I'm going to read that one more time because it's so important. Quote, while the historical analogies here and in Heller are relatively simple to draw, other cases other than Heller and Bruen, implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. Period, close quote. That is it, folks. That is the one weapon the anti-gunners have to justify their gun bans across this country under the Second Amendment. That's it. I'm going to show you why it fails utterly. To begin with, the sentence itself in Bruen points out that it's dealing with other cases other than Heller and Bruen. Heller was the gun ban case. Heller was the case that says that if a firearm is in common use, it cannot be banned. It is the gun ban test that American judges have to apply in facing a gun ban or an arms ban case. Heller reaffirmed in the sentence itself, because this reference to unprecedented societal concerns or dramatic technological changes is only in the context of other cases implicated in those things. Not Bruen, not Heller. We only care about Heller when it comes to gun bans because that is the law to be applied in gun ban cases. Number two, keep in mind that the in common use test deals with modern weapons. I repeat, the in common use test deals with modern contemporary firearms and weapons. For example, in 2016, Caetano talks about stun guns invented in the 1970s. Both in Caetano and in Heller, they say that just as we do with other aspects of the Bill of Rights, like the Fourth Amendment and others, the Second Amendment too applies to new technology. Just like our First Amendment right to use the internet, the First Amendment right to use the phone, First Amendment right to use the computer, the internet, TV, radio, ink, pens, papers, all this sort of thing. Even if it wasn't around in the 18th century, the First Amendment applies to communications using those modern technologies. So too does the Second Amendment's right to keep arms apply and protect the use of modern technologies. That's why the in common use by Americans today for lawful purposes is such a powerful test in our favor in the Second Amendment community, because it's talking about firearms in common use today. And why is that important? Just think about this for a second. It's important because any allegations of unprecedented societal concerns or dramatic technological changes, right? Dramatic technological changes are already encompassed in the in common use test. Because the in common use test measures today what weapons are in common use today in society now as we speak. So by definition, whatever it is today that we commonly own, it's already incorporated, it's already accounting for this legal test by the Supreme Court in Heller, any alleged unprecedented societal concerns or dramatic technological changes. By the way, none of that's going to be true factually. You'll like what I'm about to get to. So, therefore, in common use already accounts for all this. Those are the first two things. So again, the first thing is Heller's still good law. That's why Bruen reaffirms it. Second is the statement itself makes it clear it's only applying to future other types of cases other than cases covered by Heller. And of course, the in common use test itself covers any specific changes in society or technology. They already deal with contemporary conditions, whatever they may be. But I'm not done making the rubble bounce. The next thing you see the anti-gunners do is when they quote that language, they then go on to say, let's talk about how they actually do this. They quote that language, and next thing you know, they dump into these legal cases massive amounts of guns are bad, AR-15s are bad, magazines that hold more than 10 rounds are bad, notwithstanding the fact that, cops in Times Square and around the country use these things to protect lives, walking the same streets that we do. So they dump in all this stuff, these guns are bad. These AR-15s, they're using all these mass shootings and so on, so on, so on. So I got to thinking, what do I think about that? Well, first of all, we know that under Bruen and Heller, any kind of interest balancing, meaning guns are good or bad, totally unacceptable. It could not be clearer that the Supreme Court says cannot do any of that. Totally unacceptable. So any guns good, guns bad, guns save lives, guns don't save lives, totally irrelevant to the Second Amendment. Because again, the Supreme Court has specifically said that the balancing of any interest associated with guns and gun control or lack of gun control gave rise to the text of the Second Amendment in the 18th century, and that is what's binding on the United States, absent a constitutional amendment, and good luck with that, now that we have 27 states with permitless carry. But beyond that. So when these anti-gunners quote this language about unprecedented social change or dramatic technological changes big dramatic changes in society, societal concerns, the Supreme, they basically are saying that, the Second Amendment is special because it's kind of inherently dangerous, unlike the rest of the Bill of Rights. But the Supreme Court has already rejected that and nipped that argument in the bud. Two things here. First of all, in 2010, the U.S. Supreme Court in McDonald versus Chicago specifically rejected that line of thinking. The reason why I'm about to give you this, folks, is that I'm going to show you that all the arguments we see made, and this is very important to understand, all the arguments made today by the anti-gunners in their legal briefs are essentially identical to those arguments that were made to the United States Supreme Court in the Heller case and in McDonald. And why is that important? Because obviously, if the Supreme Court, whatever they refer to in terms of unprecedented societal concerns or unprecedented or dramatic technological changes, whatever those may be, in other cases unrelated to Heller and Bruen, it cannot possibly be the exact same arguments, the exact same concerns, issues that were raised by the anti-gun forces in Heller and in McDonald before the U.S. Supreme Court itself in those specific cases. And you'll see that they're basically the exact same arguments. So the first thing is that McDonald, the Supreme Court considered whether or not the Second Amendment should be narrowed because it, guess what, touches on public safety, public security in some way. And the Supreme Court says, no. It's not how we deal with constitutional rights. We focus on what's good, to protect it for law-abiding citizens, and that's how we do it, even if they can be abused. There's always issues associated with enforcing constitutional rights. Again, as I've always said, if you really just want to make it easy for police, there's a lot of easier ways to make it for police. Get rid of the Fifth Amendment, right against self-incrimination, get rid of a right to a trial, get rid of a right to a jury, get rid of all sorts. And there's a lot of things we can do to make it easier for the government and the cops to put us in prison. Get rid of the whole Bill of Rights. That probably would help quite a bit, but that's not how our system works. So this is what the Supreme Court said at McDonald. Quote, Second Amendment differs. Some have argued that the Second Amendment differs from all the other provisions of the Bill of Rights because it concerns the right to possess a deadly implement and thus has implications for public safety. And those respondents note that there is intense disagreement on the questions of whether private possession of guns in the home increases or decreases gun deaths and injuries. But here's the key language. The right to keep and bear arms, however, is not the only constitutional right that has controversial public safety implications. All of the constitutional provisions that impose restrictions on law enforcement and on the prosecution of crimes fall into the same category. Bing, 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 bing. The U.S. Supreme Court said that other aspects of the Bill of Rights also concern public safety considerations. Criminals go free because of the government violated the Fourth Amendment. Criminals go free because you can't force them, you can't torture them and make them confess, so on and so on and so on. Supreme Court says this is not unusual. This is part of our system. Guilty people will go free. Criminals will go free. Bad things will happen. It's kind of the cost of doing business when you're protecting the fundamental rights associated with the Bill of Rights, including, but not limited to, the Second Amendment's right to keep and bear arms. That's not Mark Smith. That's not the four boxer diary. That's the Supreme Court itself. But let me continue on. And this is important. I went back and took a look at the brief submitted in Heller versus the District of Columbia in 2008. Hear me out, before the U.S. Supreme Court decided Heller. And what I wanted to look for was whether or not the same sorts of arguments we're seeing today against AR-15s and magazines and so on, modern firearm technology, were also raised to the Supreme Court in 2008, with the thinking being, well, if the Supreme Court was aware of these arguments and still came up with the in common use test, then obviously in today's world, that one sentence in Bruen, which has nothing to do with Heller, that one sentence, of course, cannot possibly constitute a basis to do unprecedented anything, because the arguments and concerns and technology would not be unprecedented because of the exact same concerns and technology issues that were raised in 2008 in Heller, that the Supreme Court gave us the very favorable in common use for lawful purposes test. Nothing has changed since 2008. It's the same arguments. And yes, indeed, it turned out that my assumption, my guess, has proven true. Here is some of the language that we can find, and this is in my paper, you can check it out for yourself, in some of the briefs submitted by the District of Columbia and Heller, as well as the amicus support. Tell me if this sounds familiar, but keep in mind, 2008, this was argued. And now in 2022, these exact same arguments are being advanced in 2022, 2023, which means by definition, they can't be unprecedented or dramatic changes, because they're the exact same issues that were confronting the U.S. Supreme Court in 2008 in Heller. It gave rise to a victory for the Second Amendment, as well it should. Here's some of the quotes from briefs submitted in Heller. Quote, "In the recent Virginia Tech shooting, a single student with 2 handguns discharged over 170 rounds in 9 minutes, killing 32 people and wounding 25 more. That was the 2007 Virginia Tech shooting, where an individual used semi-automatic handguns with obviously magazines to kill 32 people and wound 25 more in 2007, before Heller was decided in 2008. So obviously mass shootings by single individuals using semi-automatic firearms is not new in 2023. Notwithstanding the mouthing and ad nauseum association and rhetorics and talking and discussion of that language from Bruen that the anti-gunners are using about unprecedented societal concerns or dramatic technological changes, the same stuff they're arguing about mass shooting and a lot of people killed in short periods of time was argued right here in the Heller case before the court decided. Let me continue. In Heller, this is another argument that was made to the Supreme Court in Heller in 2008. Quote, "When more rounds are fired and guns can be quickly reloaded, the likelihood of inflicting wounds and the severity of the resulting injuries increases. This unfortunate fact is illustrated all too often in mass shootings in America's schools, malls, places of worship, and other public arenas." 2008, Heller, same argument that we're seeing today. So if it's the same argument and the same arguments, the same points, same observations about society and the technology of modern firearms law that are being made in 2008, that we're seeing in 2023, what do we know by definition? That what's being discussed here is not an unprecedented societal concern. There's precedent for it. It's old. It's been around. Nor is there any dramatic technological change that's occurred between 2008 and today. It's the same stuff. Same stuff, just rehashed and regurgitated and reiterated All they simply have done, as you can see in the anti-gun movement, is they went from handguns bad, rifles good in 2008 to today they now have rifles bad, handguns good today. That's it. Let me continue on. Also submitted in Heller before the U.S. Supreme Court, quote, handguns are also used in an extraordinary percentage of this country's well-publicized shootings, including the large majority of mass shootings. A review of 50 high-profile shootings over the past 4 decades revealed that from 1980 onward, the bulk of these incidents were mass shootings. A handgun was used 74% of these mass shootings as the only or primary weapon, period, close quote. Again, sound familiar? This is not in 2023. These quotes come from briefs to the Supreme Court in 2008. I continue on. The D.C. Council targeted handguns. Quote, the D.C. Council targeted handguns because they are disproportionately linked to violence and deadly crime. Sound familiar? It should. 2008. Not unprecedented. No dramatic technological changes. It's all the same stuff. It's just rehashed by the anti-gunners, trying to slide in through that quote-unquote exceptional sentence from Bruen. It's not applicable, and even if it were, they can't prove that the language is satisfied. Why? Because as you can see, there's no dramatic change from 2008 in the technology. It's all semi-automatic firearms, modern firearms, like we saw at Virginia Tech in 2007, and the societal concerns about these mass shootings and individuals doing a lot of damage in a short period of time. All the same stuff the Supreme Court confronted in 2008 in Heller. Well, guess what? No get-out-of-jail-free card for the inferior courts. You got to apply Heller. Let me continue. The District of Columbia considered evidence indicating that murders, robberies, and assaults were more likely to be committed with a handgun. Based on this evidence, the district concluded that handguns were uniquely dangerous, period, close quote, uniquely dangerous. Guess what? You take those decisions out of Oregon, those decisions out of Washington State, those decisions out of places like Rhode Island and Delaware. You type in words like uniquely dangerous or unusually dangerous or dangerous, bing, 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 bing. Guess what? You're going to find this kind of like stuff reiterated in those opinions denying motions for a preliminary injunction on the grounds that this is an unprecedented, dramatic technological change. Well, hardly, because all this stuff was going on in 2008, before the Supreme Court decided Heller. So it's up to those inferior courts to apply the law as given to them. Let me carry on. Another argument that was made to the Supreme Court in 2008, quote, handguns are guns specifically designed to kill human beings. No duh, of course. They're guns, they're weapons. Quote, handguns for the civilian market now fire ammunition capable of piercing body armor. Body armor. The last line of defense responsible for saving thousands of police officer lives. So even back in 2008, the anti-gunners were using the body armor argument, armor-piercing bullets, saving police lives, and so on and so on. Again, these are not new societal concerns. This is not any kind of dramatic technological change, and none of it, of course, legally is relevant, because as long as these weapons are in common use, they are protected, period, full stop, because Heller remains good law. So as you can see, that language from Bruen does nothing at all in favor of the anti-gun movement if you're serious and honest about how these laws work together as I see it. Okay, I want to sum up. I know I've taken a little bit more of your time than I usually do today, but I've only done it because this is so important. This is so important that people that are arguing this stuff in courts and beyond get this right. Because what I've articulated based on my review and analysis, I think is spot on and a death sentence, if you will, of the silly argument made by the anti-gunners that one sentence in Bruen gets them out of jail, gets them away from having lower courts be forced to apply the binding Supreme Court precedent of Heller. Now, I just want to talk one more minute and then I'm going to wrap up. We're going to get a little geeky here. The way to understand what happened here is, again, Heller laid out the methodology of interpreting and applying the Second Amendment's right to keep and bear arms. It said the methodology was you start with the text of the Second Amendment, where the right to keep means to possess, the right to bear means to carry, arms includes bearable arms. Okay? You start with the text, and then you look to see if there's a historical tradition of regulation, meaning actual laws. The only thing that Heller could come up with to justify a handgun ban or any kind of an arms ban was a longstanding arguable prohibition on the ability to restrict the carrying of dangerous and unusual weapons. And from that, the Supreme Court said, based on that and the history of the militia, among other things, I won't bore you with the details here, weapons that are in common use by Americans for lawful purposes are by definition not dangerous, unusual, and simply cannot be banned. And because and that was the test. You see what I'm saying? The interpretive methodology of figuring out the legal test. They did that methodology of looking at the text and the history. And then after they did that methodology, they did that process, they came up with the test, the reason of decision, in that case, the in common use test. And then they took that test and they applied it to the facts of the case. In Heller, it was the D.C. banned handguns for all intents and purposes. And they said that that D.C. law that banned handguns violated the in common use test and therefore, by extension, violated the Second Amendment's right to keep bear arms and must be struck down. Okay? In Bruen, did the exact same thing in the context of whether or not may issue discretionary licensing regimes violated the Second Amendment. Again, what the court did there is the exact same methodology, the same interpretive methodology that they did in Heller. They started with the text of the Second Amendment. They said, well, obviously the right to bear arms means the right to carry them. Hello. Then they go on and say, what is the historical regulations restricting any kind of public carriage? And they basically said they were very limited, if any. Again, the point there is they came up with very limited of anything that restricted that in any real sense, other than arguably some sensitive place arguments and stuff like that. But whatever was the test they came up with, that given government the discretion to deny permits to Americans, if they're not prohibited people, was unconstitutional and could not be done. And in the case of Bruen, so that was the test, that if you have unbridled discretion by government officials who have the authority to yay or nay whether or not you get to carry guns outside the home, that violated the Second Amendment, and that was the test. Then they took that test and applied it to the New York law that said that we get to determine whether or not you have the right to carry guns because we think it's a privilege, and they said that the New York may issue permitting scheme was unconstitutional, and they struck it down. You see, you have the methodology of interpretation, text, and then history. Then that gives rise to a test. And then after the test, you apply the test to the facts of the case. And the reason why I just laid that methodology out, that process out, is because the language in Bruen about unprecedented societal concerns or dramatic technological changes is specifically referring to other types of cases that have yet to be decided by the Supreme Court. It is not an excuse for anti-gunners and courts that are sympathetic to the anti-gun cause to use that one sentence in Bruen to go back and undo and redo what the Supreme Court did in Heller, because that language is talking about other future cases that have yet to come before the courts. For example, whether or not you can carry a gun on the space shuttle, whether or not you can carry a gun on an airplane. These are the kinds of things, because that's a new technology. That's what that language is talking about. It's not talking about firearms technology and changes in firearms technology at all, because the in common use test already encompasses all changes in firearms technology, dramatic or otherwise, because again, if Americans are commonly using it for lawful purposes, is protected, period, full stop, regardless of any societal concerns or any technological considerations at all, period, full stop. So, all right, I know this is a little bit more complicated. I know this was longer. I hope this was helpful. Feel free to check out my article. Give me some comments below. If you have any questions or criticisms, let me know. And again, I appreciate your time. If you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.